Welcome. Thank you for joining us today. My name is Fran Carrillo, and I am the Chair of Voter Empowerment for the League of Women Voters San Diego. I'm very pleased to be introducing you to this recorded prop talk in preparation for the November 3rd election. Hopefully you all received a link to the simple form that we created that will allow you to take notes as you go. First, a little history about who we are. The League was founded in 1920 and has chapters throughout the nation. San Diego is one of the oldest and largest memberships in the United States. This year, we are celebrating the League's 100th anniversary of fighting for and promoting democracy. As some of you may be aware of, the League upholds a long and strong tradition of providing reliable, nonpartisan information. Although you may hear of us advocating for some policies over the years, we never, and I stress never, support or oppose political parties or candidates. In this recording, you will be hearing several speakers reviewing our studies on each proposition and measure. This research was initially conducted by our volunteers in our League's Public Policy and Speaker Bureau's committees. Depending upon your setup today, you may have one or more of our speakers available for live questions at the end. Please note that all our speakers are volunteers who volunteer their time to learn the propositions and measures to ensure that they can share the information with others like you in a friendly and understandable format. Our speakers are from all walks of life and are diverse in the experiences. We hope you'll be able to benefit from our presentation and their insight. We're going to start with the chair of the Speakers Bureau, and that is Jeannie, who will be presenting our program.
Hello, everyone. My name is Jean Widener, and I'm chair of the Speakers Bureau this year for the League. And I'd like to go over with you how the League evaluates the propositions on the ballot, and also how you should view them as you do your own research. The primary question is, what exactly will each proposition do if passed? It's also important to know if there's any existing law that will be changed by the measure, and especially if there's a certain group or groups of people who will benefit from it. From a taxpayer's standpoint, we need to ask how much will it cost and who's footing the bill. Finally, a lot of information can be determined by who supports or opposes it and who's paying for the advertising, pro or con. Knowing who was instrumental in getting it on the ballot, whether from lawmakers or citizens, can also provide useful background information in evaluating the intention for each proposition.
With regard to that support or opposition to each measure, we present the pros and con arguments for each proposition. But I want to emphasize that these are the published arguments from the respective individuals or organizations who have placed them on the ballot. The League does not vouch for their accuracy, and they do not necessarily represent our viewpoint on them. Please critically view these arguments in the light that they may not always represent the truth.
There are 12 state propositions on the ballot this year, and we've divided them into categories for this presentation so that you can better compare and contrast those that deal with specific issues. The 4 categories we are using include property tax and rent control, criminal justice, health care, and finally a miscellaneous category for those that don't fit into the others. This slide also shows the general order in which we will present the 12 propositions. Before I present the information on Prop 15, however, I'd like to quickly review the process by which propositions can be placed on the ballot in the state of California. Propositions are proposed laws presented to and directly voted on by the public. These can make new laws, change old ones, or change the state constitution. They can be placed on the ballot by one of 2 methods. One is by the collection of voter signatures, and that's known as a citizens' initiative. More signatures need to be collected to place a constitutional amendment on the ballot versus a statute. The second way a prop can make it on the ballot is for it to have been voted on by the state legislature, and these are called legislative referrals. One reason the legislature might prefer this over simply voting something into law themselves is that it becomes more difficult to overturn, since it would require another ballot measure to amend it. After the proposition makes it to the ballot, it requires only a simple majority for it to be passed into law. I'd like to begin our discussion with Prop 15. This proposed law would increase funding sources for public schools and communities by changing how commercial and industrial property is assessed for property taxes. It is a constitutional amendment, meaning it needed the larger number of signatures to get it on the ballot, and it was forwarded by a coalition of community organizations. Like all state propositions, it requires only a simple majority to pass. So, how did Prop 15 get on the ballot? If you are a homeowner, you probably know that Prop 13, and it was passed in 1978, prevents large increases in your annual property tax because it postpones assessment of your property until it's sold or transferred. As long as you own it, your property tax cannot increase by more than 2% annually. Since property taxes have typically increased at greater than this 2% a year, most property in the state is assessed at less than its market value. However, this discrepancy is particularly true for commercial and industrial property because these properties change hands much less frequently than residential property. The citizens groups who forwarded this measure for the ballot actually gathered signatures twice because they amended the proposition to create greater exemptions and benefits for smaller businesses. So, what exactly would Prop 15 do? Well, Prop 15 would amend the current law under Prop 13 by reassessing to market value properties that are owned by commercial and industrial entities. This would be done periodically beginning in 2022. It would leave unchanged any of the provisions that protect residential or agricultural property. And this includes all residential rental property, even if it is owned by a commercial entity. It provides benefits to small businesses by exempting them from reassessment if the property is worth less than $3 million. It also exempts them from personal property taxes if they have fewer than 50 employees. And finally, all businesses benefit from an exemption on their first $500,000 worth of personal property, regardless of their size. The fiscal ramifications of this proposition include the loss of state money due to the loss of personal property taxes, and also the administrative costs to implement the measure. After those losses are reimbursed, however, the LAO estimates that $6.5 to $11.5 billion would be generated for local services. These would be allocated locally, with approximately 40% going to public schools, and the remaining 60% for the community services such as fire protection, libraries, parks, and rec. So let's talk about who's supporting this measure and why. Some arguments in support of this measure include that Prop 15 is a fair and balanced reform that will close property tax loopholes, and it'll give tax breaks to small businesses to help our economy grow. It provides billions in new revenues for our communities and schools, and it also requires full transparency for how the money's spent. It claims that 10% of the wealthiest businesses will provide more than 90% of the revenue. And finally, it keeps Prop 13's protections for homeowners, renters, and farms. There are over 300 organizations and 600 elected and appointed officials, who support this measure, including the League of Women Voters of California. Although, as we stated earlier, the League does not share any of our positions on these measures during these educational events, we do acknowledge it when we are an official ballot signatory. So in accordance with full transparency, we signed this proposition and we have been advocating on its behalf. Some of the other people who are supporting the measure include the California Teachers Association, the Chan Zuckerberg Initiative, which is a foundation begun by Mark Zuckerberg of Facebook and his wife, and also SEIU California. The slides in our presentation can become quickly outdated with regard to contributions, so I do want to update you on the total amount raised for the measure, it has actually more than doubled in the last 10 days. And according to Voters Edge, now equals more than $41 million raised as of September 28th. So now let's take a look at who's opposing Prop 15 and why. Opponents claim that it is the largest property tax increase in California's history, that it's going to raise prices for consumers and also make it harder to start small businesses, and that it will be costly to administer. Opponents to the measure include the California Business Roundtable, the California Taxpayers Association, and the California Farm Bureau Federation. Their contributions have increased almost sixfold in the last 10 days to $31 million, according to Voters Edge. And this includes proportionally larger amounts from the three entities that are listed. So to summarize, a yes vote on Prop 15 means that property taxes on most commercial properties worth more than $3 million would go up in order to provide new funding to local governments and schools. A no vote on this measure means that large commercial properties would continue to be reassessed only upon sale or transfer. So next, you're going to hear about another proposition that affects property taxes, and that is Prop 19.
Hi, my name is Kate Parmer, and I'm a board member of the League of Women Voters of San Diego, as well as co-chair of the Youth Empowerment Committee. I'll be presenting Propositions 19 and 21. Prop 19 changes tax assessment transfer and inheritance rules, is a legislative constitutional amendment placed on the ballot as a compromise to a citizens' initiative, which was subsequently withdrawn. Jean just gave you an overview of property taxes in California, and I'm sure many of you are already familiar with Prop 13 from 1978. Prop 13 protects homeowners from getting priced out of their own homes by limiting the increase in the house's assessed value, and therefore their property taxes, by a 2% increase per year. However, when property is sold, the house is reassessed, which often results in a dramatic increase in property taxes. However, there are two major exemptions to this reassessment. The first is for certain special groups, including people over 55, people who are disabled, and people affected by wildfires and other natural disasters. Those groups can currently buy a new home without paying higher property taxes in some counties. However, the new home must not be more expensive than their existing home, and they're only allowed to do this once in their lifetime. The second exemption is for inherited property, which also is not reassessed when the heir receives it. Prop 19 would make two major changes to the tax code. The first is that it would allow those in the special groups to avoid reassessment when purchasing a new home, even if that home is more expensive than the current home. It would also allow them to exercise this exemption up to 3 times, not just the one time. Wildfire and natural disaster victims, though, would still be limited to the one-time exemption. The second thing it does is eliminate the exemption on inherited property if that property is not the heir's primary residence. According to the Legislative Analyst's Office, the revenue from eliminating the inheritance exemption is expected to offset the revenue lost from expanding the special groups exemption. The anticipated net result would be revenue of tens of millions of dollars annually, growing to a few $100 million annually, which would be applied to fire suppression efforts. Supporters of Prop 19 say that it expands Prop 13 rules for homeowners who are seniors, wildfire victims, or people with disabilities, allowing the transfer of their home's property tax value to replacement homes anywhere in California. It closes tax loopholes on inherited property not used as primary residences, directing increased tax revenue to fire protection, schools, and local government. Supporters Supporters of Prop 19 say that it expands Prop 13 rules for homeowners who are seniors, wildfire victims, or people with disabilities, allowing the transfer of their home's property tax value to replacement homes anywhere in California. They say that it closes tax loopholes on inherited property not used as primary residences, directing increased tax revenue to fire protection, schools, and local government. Supporters include 150 organizations and officials, including the California Association of Realtors, who've contributed $30.7 million in advocacy efforts. Supporters also include the National Association of Realtors, who've contributed $4.87 million to advocacy efforts, and the California Professional Firefighters, who've contributed $100,000 to advocacy efforts. There's been a total of $35.68 million raised as of September 13 of this year. Opponents of Prop 19 say the California Constitution was amended 3 times to protect the rights of families to pass their homes and up to $1 million of other property to their heirs without changing the Prop 13 tax assessment. They say that reassessment to market value will force families to sell their property because they cannot afford higher property taxes. Opponents include 8 organizations and officials, including the Howard Jarvis Taxpayers Association, who've contributed just over $45,000 in opposition. They include Senator Patricia Bates of District 36 and Assemblyman Ken Cooley of District 8. That $45,000 from the Howard Jarvis Taxpayers Association is the total amount in opposition, raised in opposition as of September 18th of this year. So in summary, a yes vote means that all homeowners who are over 55 or who meet other qualifications would be eligible for property tax savings when they move up to 3 times, including to more expensive homes. A yes vote also means that only inherited property used as primary homes would be eligible for property tax savings. A no vote means that those same special groups would continue to be eligible for property tax savings when they move, but only once, and only to homes with equal or lesser value of their current home. A no vote also means that all inherited property would continue to be eligible for property tax savings. Okay, Proposition 21. Prop 21 expands local government's authority to enact rent control on residential property. It's a citizens' initiative brought forward by the AIDS Healthcare Foundation. Back in the 1970s and 80s, various rent control measures were enacted across California, which prompted a backlash law in 1995 called Costa-Hawkins Rental Housing Act, which prohibits rent control on single-family homes and any housing built after early 1995. In the meantime, renting in California has become increasingly expensive, including being home to 6 of the nation's 11 most expensive rental markets: San Francisco, San Jose, Oakland, Orange County, San Diego, and Los Angeles. Prop 21 would modify Costa-Hawkins to allow for rent control on all housing that is more than 15 years old, as opposed to the current law of housing built before 1995, and it allows for rent control on single-family homes if the landlord owns more than 2 properties. It further allows for rent control on new tenants, not just existing tenants. However, it does continue to require that, even with the rent control, the landlord receives a, quote, fair rate of return. According to the Legislative Analyst's Office, the fiscal impact of Prop 21 would be that the value of rental properties would likely decline due to some landlords selling their rental properties. This would result in lower assessed valuations and therefore lower property taxes, which could reduce state and local revenues by tens of millions of dollars annually. Supporters of Prop 21 argue that homelessness is a serious and growing problem. Small increases in rent can force more families into homelessness, which can be a burden on the entire community. They also argue that the high cost of housing in California leaves many seniors and veterans with too few resources for necessities such as food and medical care. They say that Prop 21 guarantees the landlord a fair rate of return and that it allows local communities to limit their rent increases and preserve affordable housing. There are more than 200 organizations and officials in support of Prop 21, including the AIDS Healthcare Foundation, the California Democratic Party, and several labor unions, local tenants, and housing groups. There has been $6.83 million raised in support of Prop 21 as of September 13th of this year. Opponents of Prop 21 say that more than 60% of California voters rejected a nearly identical proposal in 2018. They argue that rent control results in less available and hence less affordable housing. They say that Prop 21 will reduce the number of new housing units built, cost jobs, and hurt the economic recovery, and that a nonpartisan analysis estimates that if Prop 21 passes, housing values could be reduced by up to 20%. Opponents include 135 organizations and officials, including the coalition sponsored by California Apartment Association, which has contributed $1.46 million in opposition. Opponents include Issues PAC of the Apartment Association of Greater Los Angeles, which has contributed $138,000, the California for Affordable Housing Group, which contributed $169,000, and Governor Gavin Newsom. As of September 13th of this year, there has been a total of 44.68 million total raised in opposition of Prop 21. In summary, a yes vote means that state law would allow cities and counties to apply more kinds of rent control to more properties than under current law. A no vote means that state law would maintain current limits on rent control laws cities and counties can apply. I'll now pass it over to Janelle, who will talk about the
Hi, my name is Janelle Van Duzen. I've been a member of the League for a little over a year. So far, I've helped with prop talks, candidate forums, and voter registration. I will be sharing about the criminal justice propositions on the ballot, Props 17, 20, and 25. Proposition 17 restores the right to vote after completion of a prison term. This legislative constitutional amendment requires a simple majority to pass. So how did this get on the ballot? Well, in 2016, California passed legislation allowing people in county jails to vote while incarcerated, but not those in state or federal prison. Prop 17 would allow California to join the 16 states plus Washington, D.C., who automatically restore voting rights for those that have completed their prison sentences, including those on parole. Parole, by definition, is the supervised program for people after being released from prison. Average parole terms are about 3 years, although some are 5 or even 10 years in length. Prop 17 will restore voting rights to people released from prison and on parole. Those eligible may also be able to run for elective offices if qualified. So what is the fiscal bottom line? This would annually cost the state hundreds of thousands of dollars. This would also increase the number of people who can vote, which would increase the workload of county election officials. And the state would have to do a one-time update of the voter registration system, likely resulting in a one-time state cost in the hundreds of thousands of dollars, which is less than 1% of the state's current general fund budget. Supporters say that nearly 50,000 Californians who have completed their prison sentences pay taxes at the local, state, and federal levels, but are not allowed to vote at any level of government. Also, when a person completes their prison sentence, they should be encouraged to re-enter society and have a stake in their community. Some of the supporters include the League of Women Voters of California and Jay Jordan, the Executive Director of Californians for Safety and Justice. As of September 13th, supporters have raised over $477,000. Opponents say that Prop 17 would allow criminals convicted of violent crimes to vote before completing their sentence, including parole. Parole proves rehabilitation before full liberty, including voting rights, are restored. If the state doesn't trust them to choose where to live or travel, it must not trust them with decisions that will impact the lives and finances of other members of society. Opponents include Harriet Salerno, founder of Crime Victims United of California, and Jim Nielsen, retired chairman of California Board of Prison Terms. As of September 13th, there was In conclusion, a yes vote means people on state parole who are U.S. citizens, residents of California, and 18 or older would be able to vote if they registered. A no vote means people on state parole would continue to be unable to vote. Proposition 20 would give stricter parole measures for nonviolent crimes and would make certain offenses that are currently treated as misdemeanors into felonies. Felonies are the most serious kinds of crimes. Generally, a crime is considered a felony when it is punishable by more than a year in state prison. When people get out of prison for a felony, they may spend time on parole. Misdemeanors, on the other hand, are less serious crimes and are typically punishable by up to a year in county jail. In 2011, the Supreme Court ordered California to reduce our overcrowded prisons. So over the past 10 years, California passed 3 measures: AB 109, Prop 47, and most recently, Prop 57 to decrease the prison population. AB 109 transferred nonviolent people from prisons to county jails. Prop 47 redefined certain nonviolent felonies to misdemeanors. And Prop 57 increased the possibility for parole for people convicted of nonviolent felonies. Prop 20 would partly undo these laws. Prop 20 would do 4 main things. 1. Limit access to parole programs for some nonviolent offenders. 2. It would make some theft crimes currently chargeable as misdemeanors into felonies, including when the value is between $250 and $950. 3. It would require convicted persons to submit to the collection of DNA samples for the state database. And 4. It would establish 2 additional types of wobbler crimes in the state code: serial crime and organized retail crime. A wobbler crime is a crime that prosecutors can charge as and judges can sentence as either a misdemeanor or a felony. This proposition would increase state and local correctional costs in the tens of millions of dollars annually due to increases in county jail populations. It could also increase the state and local court-related costs by several $millions annually, and may require the building of more prisons, which would further increase costs. Supporters say Prop 20 would reclassify certain crimes like assault with a deadly weapon, date rape, and child abuse as violent crimes, and it would help stop car break-ins, shoplifting, and other thefts that have been on the rise. Over 200 organizations and officials support this proposition and have raised over $380,000 as of September 13th. Opponents say Prop 20 would roll back prison reforms, cost taxpayers millions of dollars annually, and would result in extreme sentences for petty theft. 75 organizations oppose Prop 20, including former Governor Jerry Brown, the ACLU, and the Chan Zuckerberg Initiative. Those 75 organizations have raised over $5.5 million as of September 13th. In summary, a yes vote means that people who commit certain theft-related crimes could receive increased penalties. Additional factors would be considered for releasing certain inmates from prison early, and law enforcement would be required to collect DNA samples from adults convicted of certain misdemeanors. A no vote means penalties for people who commit certain theft-related crimes would not be increased. There would be no change to the state's process for early prison release, and law enforcement would collect DNA samples from adults only if they are arrested for a felony or are required to register as a sex offender or arsonist. Prop 25 is a referendum on a law from 2 years ago that you might remember, SB 10, that would eliminate the money bail system and replace it with a risk assessment-based system. So how did this get on the ballot? In 2018, SB 10 passed, which would eliminate the money bail system so that people arrested might not have to post bail in order to stay free pending their trial. SB 10 did not go into effect because this referendum was filed. This referendum was funded by Californians Against the Reckless Bail Scheme, a PAC composed mainly of bail bond companies.
What would Prop 25 do? Prop 25 would allow SB 10 to go into effect and would eliminate the current money bail system and replace it with a system based on risk assessment to determine whether a person charged with a crime should be released from jail while awaiting trial. High risk and medium risk people would remain in jail until arraignment. This new process would increase the workload for state trial courts, district attorneys, and public defenders. These costs could be in the hundreds of millions of dollars annually, less than 1% of the state's current general fund budget. This could possibly reduce jail costs if fewer people are being held in jail, and fees paid to the state on bail bonds would be reduced. The actual size of these effects are uncertain and would depend on the interpretation and implementation of the proposition. The supporters say the current system favors rich defendants who can easily make bail. Poor defendants would remain in jail, and those eventually found not guilty or not even charged may be stuck with large debts to pay off the bail and/or fees. 75 organizations and elected officials support this proposition, including the Anti-Recidivism Coalition, California Federation of Teachers, and the California Democratic Party. In total, supporters have raised over $8 million as of September 13th. Opponents of Prop 25 believe the intentions of SB 10 are good, but its provisions may effectively result in more people being jailed than under the current situation. It would also cost taxpayers hundreds of millions of dollars a year, overburdening courts and creating new bureaucracy. 120 organizations oppose this proposition, including various bail bonds companies, the California Black Chamber of Commerce, and the California State Conference of the NAACP. In total, these 120 organizations have raised over $5 million as of September 13th. In conclusion, a yes vote means no one would pay bail to be released from jail before trial. Instead, people would either be released automatically or based on their assessed risk of committing another crime or not appearing in court if released. A no vote means some people would continue to pay bail to be released from jail before their trial, and fees may continue to be charged as a condition of release. And up next is Francesca. She is going to share with you about the healthcare propositions on the ballot this year.
Hello, my name is Francesco Wedemeyer, and I am a volunteer with the League of Women Voters San Diego. Today I will be sharing two propositions, Proposition 14 and Proposition 25, both of which are in regard to the healthcare available to all of us here in California. To begin with, we have Proposition 14, which authorizes bonds continuing stem cell research. It's a citizens-initiated statute and is forwarded by Robert N. Klein, Chairman of the Independent Citizens Oversight Committee of the California Institute for Regenerative Medicine, CIRM. It needs only a simple majority of 50% plus 1 to pass. How did this proposition get on the ballot? In 2004, voters approved $3 billion in bonds for stem cell research, resulting in a variety of projects and trials. That money is almost completely spent, and the original backers, led by Robert N. Klein, gathered signatures to request another bond measure to continue their work. What would Proposition 14 actually do? It would permit the state to borrow $5.5 billion to fund grants from the California Institute of Regenerative Medicine. These funds would go into stem cell research, therapy and development, medical training, and construction of research facilities. It dedicates approximately $1.5 billion of these funds going specifically to research and therapy for brain and nervous system. The limit bond issuance is at $540 million per year, and it postpones repayment. What is the fiscal bottom line of this proposition? The total estimated cost is at approximately $7.8 billion, which the state would not repay all at one time. It would repay out over the course of 30 years at approximately $260 million per year. One idea is that the cost of this investment could be offset by a provision that requires payment from new inventions. So if any sort of patents or medical breakthroughs or discoveries are made by CIRM, that money could actually come back to California and help to repay off the bonds. The same provision went for Prop 71 in 2004, when $3 billion in bonds was invested, and we were able to recoup approximately $350,000 over the course of 16 years. Who are the supporters and opponents of Proposition 14? On the supporter side, we have noted individuals from the American Association for Cancer Research, the American Diabetes Association, and the Department of Medicine at Stanford University. Their argument is that nearly half of all Californian families include someone who could benefit from stem cell research, treatments, and cures. Another argument is that the original stem cell funding has led to significant treatments and cures, including 92 FDA-approved clinical trials and over 2,900 medical discoveries. The third argument is that new revenues, economic activity, and jobs will be generated by this investment that will contribute to California's economic recovery and will only cost an average of less than $5 per person annually. The supporters have raised over approximately $6.5 million as of the 18th of September. Who are the opponents of Proposition 14? The opponents are mainly two noted doctors as well as the Howard Jarvis Taxpayers Association. Their arguments are that this proposition wastes billions in the middle of an economic crisis with soaring unemployment and budget shortfalls. The second argument is that it funds a bureaucracy with serious problems, and some have questioned, quote, the integrity and independence, end quote, of the state agency overseeing these funds. The third argument is that outside of just CIRM, other institutions, private investors, small companies, startups could actually take on the initiative of studying stem cell research instead of a single institute. And finally, Prop 14 means higher taxes or layoffs, or both. Paying back the cost could mean huge tax increases or laying off thousands of nurses and other heroes who do the real work of keeping California healthy. There is no data currently available on the funds being raised in opposition to date as of the 18th of September. The bottom line, if you vote yes or you vote no on Prop 14, what does that mean? A yes vote means that the state could sell $5.5 billion in general obligation bonds primarily for stem cell research and the development of new medical treatments in California. A no vote means the state could not sell $5.5 billion in general obligation bonds, primarily for stem cell research and the development of new medical treatments in California. Moving on to Proposition 23. This proposition establishes state requirements for kidney dialysis clinics and requires on-site medical professionals. It is a citizens' initiative statute forwarded by the SEIU-UHWW and needs a simple majority of 50% plus 1 to pass. How did this proposition get on the ballot? This is the second attempt by the Service Employees International Union, United Healthcare Workers West, to pass legislation as part of the union's effort to unionize the two largest owners of CDCs, DaVita Incorporated and Fresenius Medical Care. Prop 8, which was on the ballot in 2018, was intended to require dialysis clinics to issue refunds to patients' payers and was rejected by 59.9% of voters. What would Prop 23 do? Chronic dialysis clinics, or CDCs, would be required to have at least one licensed physician on site during treatment hours, with certain exemptions. They would be required to report dialysis-related infection data to state and federal governments. These CDCs would be prohibited from closing or reducing services without state approval. And finally, they would be prohibited from discriminating patient care based on their insurance. So, for example, if a patient came with Medicare or with Medi-Cal or with private insurance, they would all have the same level and quality of care available to them at a chronic dialysis clinic. What does this mean at the financial bottom line? The increased cost for CDCs is estimated to be several $100,000 annually on average per CDC if they were to have a doctor on site during all treatment hours. If government entities negotiate higher payment rates and in addition patients need to go to more costly settings like hospitals due to there being fewer CDCs, healthcare costs could go up for state and local governments by the low tens of millions of dollars annually. Who are the supporters and opponents of this initiative? Supporters include the San Diego County Democratic Party and the Service Employees International Union, United Healthcare Workers West. And they've raised approximately $6 million as of September 13th. Their arguments are that dialysis is a dangerous procedure, and if something goes wrong, a doctor or highly trained nurse should be nearby. Their second argument is that dialysis patients are prone to infections from their treatments, which can lead to more serious illnesses or death. Proper reporting and transparency of infection rates encourage clinics to improve quality. Their third argument is that strong protection should be provided to vulnerable patients when clinics close. On the other side, the opponents of Proposition 25 are over 100 organizations, including DaVita and Fresenius Medical Care, which you may remember are the two largest providers of CDCs, and AMVET's Department of California. They have raised over $73 million as of September 13th. Their arguments are as follows. First, they argue that the increased cost of requiring on-site physicians at every clinic would force clinics to cut services and even close. Full-time on-site physicians are not necessary because dialysis patients are already under the care of their personal kidney physician, and dialysis treatments are administered by specially trained personnel. They also argue that Proposition 23 could make our physician shortage worse and lead to more emergency room overcrowding. Their third argument is that Proposition 23, funded by a special interest group with no expertise in dialysis, is another example of the abuse of our initiative system. Okay, so by voting on Proposition 23, what does a yes mean and what does a no mean? A yes vote means chronic dialysis clinics would be required to have a doctor on site during all patient treatment hours. A no vote means chronic dialysis clinics would not be required to have a doctor on site during all patient treatment hours. So that is all of Prop 23, and thank you so much for your time, and I hope that this was helpful in learning about Prop 23 and Prop 14. And please go out and vote. All right, bye-bye.
Hi there, I'm Meg Thode. I'm a newer member of the League. I just joined this summer, July 2020, and I've jumped right in with youth empowerment, marketing, graphics, and now voter education and outreach. Today I'll be presenting Props 18 and 22. Awesome. Next up, we have Proposition 18. Prop 18 would allow 17-year-olds to vote in a primary or special election, but only if they will turn 18 before the general election in the same cycle and are otherwise qualified to vote. This proposed constitutional amendment was put on the ballot by the legislature. Engaging young voters has been a concern for some time, and the rationale behind this proposal is to incentivize youth participation by allowing them to vote in both the primary and the general election in the same election cycle. Having the opportunity to be involved in choosing which candidates will compete in an upcoming election could motivate young people to take the next step and vote in the general election. What would Prop 18 do? Currently, a young person in California may pre-register to vote when they turn 16, which automatically registers them when they turn 18. However, they may not vote in either a special, primary, or general election until they have actually turned 18. Prop 18 would allow otherwise eligible 17-year-olds to participate in the complete voting cycle if they will be 18 by the general election. This also means that because these 17-year-olds will be lawful registered voters, they would be permitted to run for office if they otherwise qualify. What are some of the fiscal effects? If Prop 18 passes, it would cost hundreds of dollars for counties across California every 2-year election cycle. This would be to pay for extra voting materials and staff time. There would also be a one-time cost of several hundreds of thousands of dollars to the state in order to provide support for this change, including updating voter registration systems. For context, the total cost would be considerably less than 1% of the state's general fund budget. Supporters of this proposition make a couple of arguments in favor. Prop 18 would allow 17 and 18-year-olds to participate in a full election cycle. Prop 18 will increase participation in electoral process among young people. Because so many public policies directly impact the lives of young people, many of whom do work and pay taxes, they should be allowed to vote. This measure would promote the habit of voting, which evidence shows increases the likelihood of voting in the future. In other words, voting is habit forming, and starting early increases likelihood of participation in the future. No conservation voters. Now for opponents, opposition of Prop 18. They say 17-year-olds do not pay property taxes, therefore they should not be able to vote on bond issues involving taxes and public debt. They say 17-year-olds lack the maturity to vote and need more life experience. 17-year-olds could be easily influenced by their teachers or parents who tend to advocate for certain propositions. Particularly, educators might advocate on school bond measures. And 17-year-olds' brains have not yet fully developed when it comes to logic and reasoning. Major opponents include the Election Integrity Project of California and the Howard Jarvis Taxpayer Association. So to wrap it up, what does a yes vote and a no vote mean? A yes vote means that you agree that young people who turn 18 by the time of the general election should be able to vote in the primary of the same election cycle, even if they are only 17 at the time. A no vote would retain the status quo that one must have turned 18 before voting in any California election. And that's Prop 18. Next up is Prop 22, which exempts app-based transportation and delivery companies from providing employee benefits to certain drivers. This is a citizens' initiative statute, and all statewide ballot measures can be approved by a simple majority vote of the people. So a little bit of history. First up, Assembly Bill 5, or AB 5. This bill passed in 2019 required that rideshare and delivery companies, for example, Uber, Lyft, DoorDash, categorize their employees, their workers as employees instead of independent contractors. They achieved this through the creation of a 3-factor test that decides the status of an independent contractor. The rideshare and delivery workers did not pass the test to be considered independent contractors. The response to AB5, rideshare and delivery companies refused to implement the mandates from AB5. This resulted in a pending court case between the California State Attorney General and the violating rideshare and delivery companies in California's First District Court of Appeals. So from all of that, Prop 22 is drafted. What would the effects be? Prop 22 classifies drivers for app-based transportation, rideshare, and delivery companies as independent contractors, not employees, unless the company sets drivers' hours, requires acceptance of specific ride or delivery requests, or restricts them from working for other companies. Independent contractors as not covered by various state employment laws, including minimum wage, overtime, unemployment insurance, and workers' compensation. Instead, independent contract drivers would be entitled to other compensation, including minimum earnings, healthcare subsidies, and some form of medical and disability insurance. This proposition also restricts certain regulation of app-based drivers at the local level, and it criminalizes impersonalization of drivers. Some of the benefits, it does give drivers certain benefits. It grants earning minimum wage. This measure would require companies to pay 120% or minimum wage plus 20% for each hour a driver spends driving, but this does not apply to time they spend waiting or in between rides. They would also grant a health insurance stipend for drivers who normally work 15 hours per week, again, not including wait time. It pay for workers any costs incurred if they get injured while working. This measure requires that companies pay for medical costs and replace some lost income while driving. A rest policy would be put in place, prohibiting drivers from working more than 12 hours in a 24-hour period for any given company. Other requirements of Prop 22, it prohibits workplace discrimination and requires that companies, 1, develop sexual harassment policies, 2, conduct criminal background checks, and 3, mandate safety training for drivers. Lastly, it limits local government ability to set additional rules on those rideshare and delivery companies. Fiscal effects of Prop 22, there's a minor increase in state income taxes paid by rideshare and delivery company drivers and investors. Potentially lower costs and higher profits for rideshare and delivery companies because this measure allows them to hire drivers as independent contractors instead of employees. The companies would not have to pay the cost of providing standard employee benefits and protections, which usually make up about 20% of employee cost. This would allow companies to charge lower fares and delivery fees. Then with lower prices, customers would take more rides and place more orders. This could increase the company's profits, and then higher profits would increase the company's stock prices. So support for Prop 22. Supporters of this proposition have a couple of arguments. First off, they say by a 4-to-1 margin, so 80% of app-based drivers support maintaining independent contractor status due to time flexibility. The flexibility allows workers to fulfill other important obligations, like parents who work while kids are at school, or family members who work odd hours so they can care for aging parents or other loved ones, and working families, retirees, and students who need supplemental income. Second argument, loss of jobs will become prominent as AB5 dramatically changes the app-based model that has allowed quick matches between customers and drivers. An employment-based system will cause longer wait times, significantly higher customer prices, and permanent shutdown of services. All this will cause major job loss that will cause an economic downturn, they say. Furthermore, it improves app-based work by requiring companies to provide new benefits. These benefits to review include guaranteed minimum earnings, funding for health benefits, medical and disability coverage for on-job injuries, and additional protections against harassment and discrimination. Lastly, they say it creates expanded public safety protections by requiring ongoing background checks and safety courses, a zero tolerance for drug and alcohol offense policy, and criminal prosecution for impersonating drivers. Supporters of Prop 22 notably include DoorDash, Lyft, Uber, Instacart, Postmates, these very same rideshare and delivery companies. It has support from California Peace Officers Association, State Sheriffs Association, Police Chiefs Association, as well as the California Chamber of Commerce, California NAACP State Conference, as well as the National Taxpayers Union. Opposition to Prop 22 argue Prop 22 creates a special exemption that eliminates basic workplace benefits and replaces them with a new lower earnings guarantee and healthcare subsidy. All of this is designed to save the companies money. They also say Prop 22 contains deceptive wording to cynically try to convince us that they are strengthening driver protections. The truth is, Uber and Lyft are already required to perform background checks, and new provisions would eliminate required sexual harassment training and the obligation on Uber and Lyft to invest in customers' and drivers' sexual harassment claims. Prop 22, they say, is all about greater profits for ride-sharing and driving apps based, ride-sharing and driving app-based corporations for them to save money. And finally, Prop 22, one of the supporting arguments of flexible part-time work is misleading and a straight-up lie. A majority of ride-sharers and app-based drivers are full-time, with 70% working 30 hours or more, according to a University of California study. These drivers are full-time workers that deserve the same treatment as any other employee. Opponents to this proposition include 2020 Democratic Vice Presidential nominee and California State Senator Kamala Harris, Speaker of California State Assembly Anthony Rendon, former 2020 Democratic presidential candidate Senator Elizabeth Warren, and 2020 Democratic presidential nominee and former Vice President Joe Biden. As well, it has in opposition are the California Labor Federation, California Teacher Association, California State Council of Laborers, Transport Worker Union of America, as well as an organization called Gig Working Rising. So to wrap it all up, what would a yes or a no vote mean? A yes vote on this measure means app-based rideshare and delivery companies could hire drivers as independent contractors. Drivers could decide when, where, and how much to work, but would not get standard benefits and protections that businesses must provide employees. A no vote on this measure means app-based rideshare and delivery companies would have to hire drivers as employees if the courts say that a recent law makes drivers employees. Drivers would have less choice about when, where, and how much to work, but would get standard benefits and protections that businesses must provide their employees. And that's all for Prop 22.
Hi, I'm Kim Knox, Program Chair and Candidate Forums Co-Chair for the League of Women Voters of San Diego. I've been a member of the League for about 4 years, and I also participate on the Voter Empowerment, Public Policy, and Immigration and Deportation Committees. I'm presenting Propositions 16 and 24. Proposition 16 would allow diversity as a factor in public employment, education, and contracting decisions. This required a 2/3 yes vote by the legislature to make the ballot. It needs a simple majority to pass. A little background. Before 1996, California universities and government offices could factor in someone's race, gender, or ethnicity in making hiring, spending, and admissions decisions. These were often called affirmative action programs. Then, in 1996, voters approved Prop 209, which generally banned affirmative action. For the last 24 years, public entities have used modified policies and programs to instead consider characteristics that were not banned by Prop 209. For example, many of California universities provide outreach and support programs for students who are first in their family to attend college. Also, when making admissions decisions, consideration may be given to where students attended high school and where they live. Federal law allows policies and programs that consider certain characteristics to increase diversity within limits. Prop 209 is more restrictive than federal law. State lawmakers, motivated by racial inequities highlighted by the police killing of George Floyd, voted to put this measure on the November ballot. Prop 16 would repeal the section of the California Constitution introduced by Prop 209 in 1996. It would end the ban on the consideration of race, sex, color, ethnicity, or national origin in public education, public employment, and public contracting. A wider range of policies and programs could be established as long as they are consistent with federal and state law related to equal protection. What it wouldn't do is create racial quotas in university admissions. The U.S. Supreme Court banned those in 1978. The fiscal effects of Prop 16 are largely unknown. Because it is permissive and not a mandate, it would not require any change to policies or programs. Any number of decisions could be made, but because these specific decisions are unknown, the potential fiscal effects are highly uncertain. Supporters say Prop 16 would mean equal opportunities for all Californians, and California would join 42 other states which allow affirmative action. They say despite living in the most diverse state in the nation, women and people of color currently are still discriminated against. The Institute for Women's Policy Research shows that on average, women make 82 cents for every dollar earned by men. A recent study from the Economic Policy Institute showed that Black workers are twice as likely to be unemployed, even among college-educated individuals. Some examples of affirmative action include principals in a school where most teachers are white but most students are Latino, being able to specifically seek to employ qualified Latino teachers. And public universities would be able to consider a student's race as one of numerous admissions factors, including grades and schoolwork. Supporters include the University of California, California State University, and community colleges, as well as the League of Women Voters of California, both of California's senators, the governor, the San Diego mayor, and the San Diego County Democratic Party. Supporters have raised over $3.2 million as of mid-September. Opponents say approval of Prop 16 would be a step backward, introducing a new form of discrimination to favor politicians' favorites. They say that we should not perpetuate the stereotypes that minorities and women can't make it unless they get special preferences. They say Prop 16 will require costly bureaucracies to enforce its provisions, burdening taxpayers. Opponents include Ward Connerly, who was chair of the original initiative that became Prop 209, and a USD professor of law, a former US congressman, and the California Republican Party. They've raised over $122,000 as of mid-September. A yes vote on Prop 16 means public colleges, universities, and agencies would be allowed to include race, sex, color, ethnicity, and country of origin as part of their decision-making. They would be allowed to create affirmative action programs to increase diversity or to help certain groups. A no vote means the current ban on affirmative action would remain in effect. Proposition 24 amends consumer privacy laws. It was a citizens' initiative and it requires a simple majority to pass. In 2018, a San Francisco-based real estate developer, Alistair McTaggart, was the proponent of a ballot initiative regarding consumer privacy. Despite a $100 million opposition campaign funded by major tech companies, he got enough signatures to qualify for the ballot. Then, the state legislature got out in front of the measure by passing its own compromise bill, the California Consumer Privacy Act, or CCPA, of 2018. So the original ballot initiative was withdrawn. McTaggart thought the CCPA was a great baseline, but that there were additional rights that Californians deserve. Since this is a ballot initiative, the legislature would not have the power to make amendments. It would require another ballot initiative to amend it. So, Prop 24 would amend the California Consumer Privacy Act of 2018. It would create a new state agency, the California Privacy Protection Agency, to investigate violations, assess penalties, and develop regulations. It would permit consumers to prevent businesses from sharing personal information, correct inaccurate personal information, and limit businesses' use of sensitive personal information. And it would also prohibit businesses from holding onto your data for longer than necessary. It would raise the penalty when companies violate children's privacy rights. It would increase penalties and remove the ability of businesses to fix violations before being penalized. It would reduce the number of businesses that have to comply, making it apply only to companies that buy or sell data of at least 100,000 households a year. If a financial impact statement cites that Prop 24 would add $10 million annually for the new agency. There would be costs for increased court and Department of Justice enforcement workload. But some or all of these costs would be paid for by penalties collected for violations of consumer privacy laws. There is an unknown impact on state and local tax revenues due to economic effects resulting from new requirements on businesses to protect consumer data. Supporters say Prop 24 would prevent businesses from using or sharing sensitive data about your health, finances, race, ethnicity, and precise location. It would strengthen existing protections by establishing a new California Privacy Protection Agency at a cost of $10 million a year. By virtue of being a ballot initiative, it is less vulnerable to watering down through the pressure that lobbyists put on legislators. They also say it would give consumers more ability to sue companies if their email and password are stolen or hacked. This is supported by 24 organizations and elected officials, including Californians for Consumer Privacy, Andrew Yang, founder of Humanity Forward, Alex Rooker, vice chair of the California Democratic Party. Over $5.4 million has been raised as of mid-September. Opponents say Prop 24 puts the burden on consumers to opt out of countless intrusive data collection practices, one by one, that companies are currently barred from by default. They say hidden economic discrimination persists, so people without money to spend cannot pay for loyalty programs and can expect worse connections, slower downloads, and more pop-up ads. They say Prop 24 would allow employers to keep gathering data about things like employees' pregnancies, religion, or political activism. California's data privacy law just went into effect this year, so some argue we should wait and see how it plays out before changing it. And some of the updates in Prop 24 would hurt consumers. It would delay a rule that allows workers to find out what information employers collect about them. It would make it easier for businesses to charge you more if you don't let them sell your data, and it would allow tech companies to grab your data when you leave California. Opponents also say this proposition lacks backing from a broad coalition of privacy advocates, and some of them even oppose it. It is opposed by 20 organizations, including the California Nurses Association, the ACLU of California, and the California Alliance for Retired Americans. They've raised $20,000 as of mid-September. A yes vote on Prop 24 means existing consumer data privacy laws and rights would be expanded. Businesses required to meet privacy requirements would change. A new state agency would oversee and enforce state consumer privacy laws. A no vote means businesses would continue to be required to follow existing consumer data privacy laws. Consumers would continue to have existing data privacy rights. The state's Department of Justice would continue to oversee and enforce these laws. Now, back to you, Fran.
Thank you to all our presenters. I hope you enjoyed that. On behalf of the League, I hope you are able to get the information you need and be an informed and confident voter this election season. Please note, a majority of this information can be found at these locations, which are linked under our voting resources on our website. That's www.lwvsandiego.org. That's .org. On behalf of the League of San Diego, I'd like to thank you for tuning in, and we hope you'll stay connected to our programs that we have all year round. And remember, be safe and vote this November. Thank you.